At first glance, this might seem like just another routine courtroom hearing. But in criminal law, the first few minutes are often where everything is revealed. The charges being read right now could determine whether this defendant walks free someday or spends decades behind bars. So pay close attention, because every word here matters.
Okay. All right, sir, you Kendrick O'Veal.
Yes, ma'am.
You are charged with evading arrest or detention with previous conviction, and that's from August 31st of 2025. That shows that you were previously convicted of evading arrest or detention July 22nd of 2011. So that's what makes it a state jail felony. Then the indictment further alleges you were convicted of attempted robbery, a third-degree felony, March 28th of 2013, and after that was final, you were convicted of assault, a third-degree felony.
This is the moment every defendant fears, the formal reading of the charges. And when multiple felonies are involved, the stakes multiply fast. Prosecutors stack charges strategically, which can pressure a defendant into accepting a plea deal. The question now is, will he gamble on a trial or play it safe?
September 11th of 2019. And so what that means in that case is that if you go to trial and you're found guilty, and those prior convictions are true, the range of punishment would be enhanced to a second-degree felony, which is between 2 years and up to 20 years. Do you understand?
Yeah.
And then, in cause number 25 DCCR 1777, you're charged with unlawful possession of a firearm by felon. And that is...
Here's where things start getting serious. Notice how the judge isn't just talking about the current charge. She's walking through the defendant's criminal history. In the legal system, prior convictions don't just stay in the past. They follow you into every future courtroom appearance and can dramatically increase the punishment.
From August 31st of 2025, that indictment alleges one prior felony conviction, the one from 2019, but the state can file, and I anticipate they would file, a notice of enhancement because that 2013 was left off of that indictment. And so what that means in that case is if you're found guilty and if those prior convictions are true, you would be considered a habitual offender with a minimum punishment of 25 years in prison, up to 99 years or the rest of your life. Do you understand? And then
sentence enhancements are one of the most powerful tools prosecutors have. A charge that might normally carry a few years in prison can suddenly jump to decades if prior felonies are proven. It's the legal system's way of saying, repeat behavior leads to harsher consequences.
Finally, in clause number 25 DCCR 1778, once we get all these now. You're charged with the third-degree felony offense of deadly conduct discharging a firearm from that same date of August 31st of 2025. It does allege those two prior felony convictions. Again, what that means, if you're found guilty and if those prior convictions are true, you would be considered a habitual offender in that case also, with a minimum punishment of 25 years up to 99 years or life in prison. Do you understand?
Yes, ma'am.
In all of those cases I have here on this tablet.
Did you catch that? Habitual offender status changes everything. Once someone crosses that threshold, the sentencing range explodes, from a few years to potentially life in prison. At this point, the courtroom isn't just debating guilt. They're discussing the possibility of someone spending the rest of their life behind bars.
A plea bargain rejection in each case that you've signed with Mr. Parker that shows that the district attorney's office has made an offer, if you wanted to enter a plea of guilty in your cases, to go on, probably it looks like counts 1 and 2 for a 15-year term instead of that habitual. And so in 2 of the cases a 15-year term, and then
it's 15 on all, concurrent on all of them, Judge. Yeah, because it's state jail is it.
Oh, I opened the wrong one. Sorry. Hold on, y'all. I want me to do that. That's a 30.
Oh, that's my next one.
Sorry. Okay, so 15 years in all 3 cases that would run concurrently, which means together at the same time. Do you understand what the state has offered you? And so you have every right to reject that offer and have all three of your cases set for trial. I just want to make sure you understand what the possible consequences are if you go to trial, what your options are if you wanted to enter a plea of guilty in your cases. And do you understand all of that? And do you want to reject those offers and have your cases set for trial? All right, we'll get that done. I do want to, is there any reason to believe that these offers would change?
Not at all, Judge.
So, Mr. O'Bill, I want to make sure you understand that after today, unless there is new evidence that is discovered by either your attorney or the state's attorney, I will not accept these plea agreements again. Once it's on the trial docket, it either goes to trial, you can plea open to the court, or to some different amount or negotiated punishment. Do you understand? Okay, so I will get your cases set for trial. Mr. O'Bill, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me here as a court-appointed attorney. With your permission, I can release him and I can appoint a new attorney today who could begin preparation for trial a little quicker. Is that okay with you? Okay, so Mr. Parker, you're released. Mr. O'Bill, we will appoint someone today. They should be out to see you very soon to begin preparation for trial.
This right here is the crossroads of the entire case. The prosecution is offering 15 years total if he pleads guilty today. But if he rejects it and loses at trial, the minimum sentence could jump to 25 years or even life. So the big question becomes, is he confident enough to risk trial? Or is this a gamble that could cost him everything?